My name is Laura Elmer, and I'm the Assistant Director of the Office of University Writing and the ePortfolio project. We will have food afterwards, and I hope that you continue the conversation there. But this afternoon, I'm proud to introduce to you an expert whose legal experience expands a wide variety of issues, including copyright, fair use, network neutrality, trademark prosecution, and corporate transactions involving intellectual property. Brandon Butler. He's the practitioner-in-residence at Glushko-Samuelson Intellectual Property Clinic at the Washington College of Law at Auburn American University in Washington, D.C. Formerly, he was the Director of Public Policy Initiative at the Association of Research Libraries and a lawyer in the Media and Information Technologies Practice Group at Debunking. We're excited to have him here as the ePortfolio project moves from its pilot year into its official first year of implementation. Because teaching our students technical competency is one of our goals, along with teaching students how to engage with a public audience online, the ePortfolio cohort members thought it important to bring someone to campus to help our students understand fair use policy. So with that, please give Brandon Butler a warm welcome. Thank you.
Good afternoon. Good afternoon, y'all. I'm from around here. I'm from Fayetteville, Georgia, and my family's in Modalia, Alabama. A lot of them, so it's nice to be where I can use the words that I grew up using, other than in D.C. where I have to speak more carefully. So this talk is about exercising your copyrights when you're doing multimedia projects, and I want to start off just running through some, I think, scenarios that will hopefully look familiar to you as the kinds of things that you might be doing or have seen done. Do I need to wear the mic for the video? Is that the? Yes. Okay. I was hoping I could live without it. But as you can tell, I'm very loud on my own. Okay, so I'm going to be talking a little bit about your copyrights. Rights belong not only to the author, but actually to all of us as users and members of the public under the Copyright Act and frankly under the Constitution. So I wanted to walk through some of the situations you might have already faced or that you likely will face as you engage in these kinds of ePortfolio projects where you're sharing content online. And I'm going to walk through them really quick now without any answers, and then I'll sort of present you a little bit of info about fair use and copyright, and then at the end we'll come back to these examples. So here's a scenario. I want to post a video interview I did with high school students about standardized testing, right? But there was a Taylor Swift poster in the background, looking good, and one student had on a t-shirt with an Adidas logo. You know, when I watch TV, logos are often blurred, right? And Taylor Swift is an artist, and this is a very nice poster. That stuff might all be copyrighted. What do I do? Do I need to blur them out? Or I made a mashup of a video of Buffy the Vampire Slayer and Twilight to show that Edward's behavior is creepy and stalkerish. And Buffy is, in fact, a stronger female role model than Bella. It also shows my video editing skill. Every single frame of the video is taken directly from one of those films. I shot nothing, right? I did not use a camera to make this movie. I cut it together completely from other people's stuff. Is that okay? I don't know. I want to post a series of video clips showing me putting together my kinetic sculpture. That's a real kinetic, my friend made it. All those things move. It's really interesting. So, but it's pretty boring watching me put this thing together, right? Just sort of hammering and nailing. So I want to drop in a song by Kanye West as soundtrack. It has a cool vibe. Is that okay? My senior project is about Frank Lloyd Wright and his influence on modern architecture. To demonstrate that influence, I've created a gallery of images that shows houses designed by Wright, as well as images of imitators. I didn't make any of these photos. I wasn't there. I've never been to half of these houses. I have no idea who made these photos. I found them all on the internet using Google Images. Can I post this gallery in my portfolio? My senior thesis is about Portuguese water dogs as a breed and some of the common ailments they may suffer. Can I use a picture of Bo Obama and the other one? I forget. Anybody know? There's a lady. Yeah, Bo's brother. To decorate my website. My senior thesis is about presidential pets and what they say about their owners. Can I use a picture of Bo Obama to decorate my website? And then finally, it took me a very long time to assemble the 130 articles that I cite in my thesis. Can I post them to the open web as a zip archive and save other people the trouble that I had to go to find all that stuff? So, how could we solve these vexing problems and give people advice they can live with and let them do the kinds of scholarship online that they want to do? Well, first I want to talk about copyright's purpose, which is grounded in the Constitution. And then I want to talk about fair use and the best practices approach to exercising your fair use rights. And then we'll go back to those common scenarios and use the best practices to try and start to answer those questions. And then finally, if we have time, I'll talk a little bit about risk. That's a little bit more of an institutional question. I see a lot of you folks are students, and so it might be something for me to talk to the lawyers about, or you might have a question at the end. So I'll get to that if we get to that, but the important thing for me is to help the practitioners and the faculty on the front lines understand their rights. So we'll see how we do with the risk. So first, the purpose of copyright. That's from the Constitution. It's Article 1, Section 8, Clause 8 of the Constitution. This is where Congress gets the power to create copyrights and patents. And it says, to promote the progress, as you do, of science and the useful arts. That is the purpose. The Constitution says the reason that Congress has the power to create copyright is to promote progress. In modern English, we might say to promote the creation of culture, dissemination and the discussion of culture, right? And so that is the only goal of copyright. The goal of copyright is not to ensure that authors and their children live a happy, healthy life with lots of money, right? It's not grounded in any kind of notion of human rights, which some other countries have a view that sort of authors have an inherent right, and even if it sent culture down in flames, it doesn't matter because it's more important to protect the author's right to her work. That's not our view in this country. That's not the view of the Constitution. It is about promoting progress in the culture at large, not about rewarding any particular person. So it's a very public-minded doctrine that we get from the Constitution. Now, copyright law serves that purpose in two ways. First, it rewards creators with a limited monopoly, right? That's copyright. That's the right that an author has, which we'll talk more about in a second. But it also, the law also encourages new makers to use existing culture in valuable ways, and sometimes to do that without asking anyone's permission and without paying anyone. Right? So what's this limited monopoly? Well, authors get actually a very limited monopoly. It lasts for a long time, but it's limited to a bundle of specific rights, right? Reproduction, distribution, and a handful of other things, right? So authors can't stop you from shredding the book that you own, or lending it to a friend, right? Or watching the movie as many times as you want over and over again, right? Until you have to go and eat or sleep, right? So there's not absolute total control on the part of rights holders. It's limited to a few things they get to control. The term is finite, so sooner or later authors' rights disappear and works belong to all of us, and we can all do whatever we want with them. Now that term has gotten longer and longer. You know, at the dawn of the Republic, it was 14 years. And now it is the life of the author plus 70 years. And it's just gotten longer and longer and longer over time. And the vast majority of that increase has been in the last couple of decades. It is limited subject matter, right? Copyright doesn't apply to just any old thing you write down or draw or sing. It has to be creative, and it only applies to the particular expression that you've created, not the underlying ideas, right? So if I decide that I think the idea of a story that takes place during the Civil War that makes a lot of commentary about the way of life going away and yada yada yada, right? Margaret Mitchell and her estate can't sue me unless I take her literal expression of that story. I can tell a story very similar in my own words, in my own way, right? And so that's a limited right that the author has. And then finally, there's a panoply of limitations and exceptions to copyright that apply to all kinds of very good and useful cultural institutions and actors. So teachers have special exceptions, libraries have special exceptions, churches have special exceptions, software security researchers have special exceptions. And so there are all sorts of special rights that belong to individuals that Congress had seen fit to hand out sort of one by one, like Halloween candy. And all of these exceptions encourage new makers, right? So those specific exceptions encourage new makers. And then also the public domain, works created by the government, and ideas are completely free. But by far and away, the biggest balancing feature in copyright is fair use. So all those limited exceptions are nice if they're targeted right at you. But the right that really belongs to everyone as part of their First Amendment rights is fair use, which is the legal unauthorized use of copyrighted material under certain circumstances. Right? And it's those last three words that drive everyone insane. Right? What are the circumstances in which fair use applies? Well, if you go to the statute, you will see 4 statutory factors. Right? If you go look in the Copyright Act, which I don't recommend. It's quite long and rather hard to read. But Section 107 of the Copyright Act says, judges can decide whether a use is fair using their own good judgment and equity, but based on these 4 factors. The purpose of the use, right? What were you doing when you made the copies or did whatever it is that you were doing that you're now allegedly infringing? What kind of work were you using? Was it fiction? Was it highly creative? Was it more like a map or a database? How much did you take? And what is the effect of your activity on the author's market? And those are somewhat helpful. They get you somewhat down the road, right? But it became pretty clear in the 70s and 80s as judges were struggling to apply these 4 factors to cases when they were first codified. So fair use actually was applied by judges willy-nilly for over a century before it was finally written down. But when it was written down, judges it hit the reset button, and judges started really focusing on these 4 factors, and they had a lot of issues early on trying to apply the fair use factors. But here lately, there's a lot of good news, right? So a lot of bad law was made in the 70s and 80s. But then in the last couple of decades, things have really turned around, and fair use has become extraordinarily powerful. So first, judges love these balancing features in the Copyright Act. You can tell when you read the decisions that judges know copyright is becoming longer and stronger, and that the rights of the author are becoming so extraordinary that users need a kind of counterbalancing right. And so judges are increasingly invoking fair use as they should, as they always have, as part of their equitable power to say, this is an unfair situation. The author here has way too much power to control what the user is doing, and I'm going to say, no, not this time. The user gets to make this use without asking permission. The Supreme Court, in several recent decisions, in 2 big cases, has said that fair use protects free speech. That is, fair use is a First Amendment doctrine. So even if there were no fair use right in the statute, it would be required by the Constitution. It would be required by the First Amendment. And that makes perfectly good sense, right? Imagine if you had to ask Martin Scorsese's permission before you criticized The Godfather, right? It wouldn't go down so well, right? Or if you wanted to quote a line of dialogue or show a film still to say, this is what went wrong here, and if you had to go to the director and say, do you mind if I make fun of your movie? Right? It's not going to go so well. So fair use judicial interpretation has really shifted greatly since 1990. Judges kind of got their act together. They've established a strong underlying theory of fair use. One important thing to say is that in the meantime, before judges got it together and before kind of everyone started to realize what fair use really is all about, there were a bunch of terrible guidelines that were written in the 70s and 80s and even on into the 90s. These guidelines, you might have heard of them, the 76 copyright guidelines for classroom fair use, the CCUMC multimedia guidelines. They feature a lot of hard edges, 10%, 1,000 words, 1 semester but never again for another semester. They tell you exactly what you can and can't do. And they're all totally bogus. These were private guidelines that were negotiated by private parties. They never had the force of law. And at the time they were negotiated, they were meant to be a safe harbor. That is, they were meant to state a bare minimum. If you stay under 10%, surely that's fair use. But it was never meant to be the case that if you go beyond 10%, surely it's not fair use. And so all of these guidelines have since been repudiated, rejected by federal judges, rejected by the core professional associations that govern the mediums where these guidelines used to apply. And so it is time to let go of a lot of these terrible myths that you've heard. So anything you've ever been told about fair use that involves a number, forget it. It is false. There are no numbers in fair use. There is no percentage that is magical. Anything you've been told about how many times you can use something, it is false. Forget it. There is no magical limit on how many times you can do something. The most recent case to discuss the guidelines was the Georgia State e-reserves case, and the judge said explicitly the one semester only rule, where you can share material with your students for one semester, but then after that you have to ask permission or get a license. She said, this makes no sense. Why would you do that? If it's fair use in July, how can it not be fair use again in September? This is ridiculous. And so don't take it from me, take it from Federal District Judge Orinda Evans. The guidelines are dead. And the CCUMC has actually gone so far as to officially retire their crummy multimedia guidelines. I gave a version of this talk to them, and they said, oh my God, we're doing terrible damage to people by continuing to proliferate this thing. We're retiring it, and so it's gone. If you go to their website, there's a statement that explains these guidelines have been superseded by the law. We're no longer supporting them. So now, what do, right? I've set you free. No 10%, no 1,000 words. So how, you have no cage, the gate on the cage is open. What do you go out there and do now, right? How do you know if you're safe? Well, judges have turned away from any kind of arbitrary numerical limits, and now they're asking one core question and one subsidiary question. The core question is your use transformative? And transformative is a kind of term of art. It was coined in the early 90s by a scholar named Pierre Laval, who's also a federal district court judge and now an appellate judge. And Judge Laval said, transformative uses are uses that take existing content, existing images, existing words, and use them for a new purpose. Place them into a new context, show them to a new audience, and use them to create new insights, right? These are productive uses, rather than merely superseding uses. Uses where it's just, rather than buying the album from the artist, why don't you buy it from the trunk of my car, right? That's piracy. Transformative uses are new uses, productive uses. And then if your use is new, it's for a new reason, you're adding value, you're creating something useful for society, for culture, the next question is the amount that you took appropriate to that transformative purpose, right? If your goal is criticism, how much was appropriate to take to make your critical point? And courts have found, and so let me just to drive home the thing about no arbitrary numbers, courts have now found in case after case after case that if you've got the right reason, you can use entire works, entire images, entire movies, entire audio files. You have search engine cases, publishing cases. There's a great case about the Grateful Dead, where there's a coffee table book about the Grateful Dead, and there's a timeline describing sort of the events in the life of the band, and along the timeline there are these thumbnail images of concert posters and tickets and memorabilia. And they went to Phil Graham, tried to get permission. He wanted extraordinary amounts of money, and so they just did it without his permission. And the court said those posters were advertisements for a concert. The concert is over. Now you're telling a story about the concert. And these images of posters and tickets help people understand what it was like to be there, right? And you're taking the right amount. They weren't, sort of frame quality posters. These were reproductions in the context of a book, enough to tell the story, right, and not too much. But it was the whole thing, nevertheless, right? Reduced, but the whole thing. Similarly, Google has taken entire websites for ages, right? So for as long as, not ages, for a decade, which is forever in internet time. But for as long as Google's been around, they've been copying stuff and not paid anyone a dime for the privilege. And they've won over and over and over again in court because what they're doing is transformative. They're giving us a whole new tool that makes the web work, right? This search tool. Here's another example. So from advertising to high art, right? The image on your left is an advertisement for I can't remember if it's Gucci or what, but some very high fashion slipper. And the image on your right is an enormous mural. It was sort of, 100 feet by 100 feet, made by the artist Jeff Koons. And he's an appropriation artist. This is what he does. And he took the feet from the ad and put it in his enormous mural, which makes an obvious rhetorical point that I won't bore you explaining because I know it's clear on its face. So, and he got sued, right? And the photographer who took the picture of the sandal said, "Get your own sandal," right? I took this picture. You're just taking my picture and putting it in your picture. If you want feet, take a picture of your own feet. And the judge said, no, right? This is radically different. You took that picture to sell shoes. You got paid for it, and it's selling shoes, and that's great. Jeff Koons is using it in his art, and he's telling a completely different story. Obvious what it is, I won't bore you with that. And, and that's different. And so the judge said, this is transformative. Here's another one, thumbnails for image search, right? Google doesn't own any of these images. If you search for a library on Google, you'll get all these images. How can Google show you those images if they don't own them and they never asked anyone's permission? Again, it's because they're doing something different. They're helping you find the images, right? And when you find them, you'll go through to the original artist's page or the original photographer's page or wherever those images live. And so that's why that's a transformative use. And then finally, parody, right? So you have the guy on the bottom right who did a ridiculous music video. I don't think I can say the title in mixed company, but South Park then made a parody of it, and it was so obviously fair use that the court threw the case out at a very early stage, which is important for you to know because litigating is expensive. And so you might think, oh no, even if I get it wrong, I'll get dragged into court and that's expensive. Well, fair use is becoming such a powerful doctrine nowadays that judges are throwing cases out early and they're awarding defendants attorney's fees, right? So South Park won attorney's fees because it's, why are you in my courtroom? This is so obviously fair use. You're wasting my time and you're wasting their time, and now you have to pay their lawyers. So there's another thing that judges care about these days in addition to this transformative thing, which is they care a lot about the custom and practice of individual creative communities, especially when those practices are well documented, right? And this is an insight that was developed in the mid-2000s by a professor named Michael Madison. And what Madison did was he looked at all of the fair use cases that there have been at the federal level, which is a couple of hundred, 300 or 400 cases. And what he found was that actually, from the very beginning, courts have been asking, in order to determine whether a use was fair and legitimate, they've been walking through the 4 factors, but working in the background is this question of, is this user doing something that is normal in their practice community and that is viewed as legitimate by that community, where that community is itself legitimate, right? And so the very first fair use case was a case called Folsom against Marsh, which involved dueling biographies of George Washington, right? And the first guy wrote one of these 7-volume, exhaustive, scholarly biographies, and nobody wanted to read it. And so the second guy took all the best parts and made like a 50-page condensed version, right? And the judge asked, well, now wait a minute. Second guy, you say you're a biographer, and biographers, they cite other biographies, right? I mean, this is what I'm a scholar. And, but I think this is a lot more taking than any real biographer would ever do. And if you read between the lines, that's what's really going on in that case, is that the second biographer is not living up to the standards and the practices and the professional expectations of his community. He's taking in ways that that community would say, no, no, that's not what we do. We pay when we take that much, you know. And so, since about 2005, not long after that article surfaced, two colleagues of mine at American University, Peter Yauzi and Pat Aufderheide, have been working with communities of practice to really articulate those norms about when it is appropriate to take other people's content and use it in your professional practice, right? And so they very self-consciously sort of organized the communities, and they're growing all the time. There's 12 or 13 different best practices now. A lot of them, though, are around scholarship and education and teaching. And so you guys are very well covered by these practices. And you can reason by analogy from similar communities as well, right? Because the values are going to be very similar. So the way this process works is that Pat and Peter, and usually in collaboration with other people, so I worked with them on a code for libraries, which is the document Laura mentioned. Well, we've sent some here. They're not here yet, but there'll be 50 or 60 of them here probably tomorrow. And what we do is that first the researchers developing the code sort of parachute into a profession, right, like anthropologists. And we look around and we ask, what are the situations where you need fair use to do your job, right? You know, what are the times when you need to quote content, you need to share content, you need to incorporate other people's stuff into what you do in order to do what you do, you know, as a matter of like existential importance. And after we determine those common scenarios, and sometimes, oftentimes, people will not quite know exactly whether what they're doing is right. And so there's some insecurity, and there's a lot of working through and surfacing issues and discussing why fair use does or does not apply in these common scenarios where it is important to use other people's stuff, right? And so we get people together in small groups and discuss these situations. What would you do if you were filming a documentary and it turns out when you're editing it that there's a photo of Taylor Swift in the background, right? How would you deal with that problem? And they asked exactly that. Probably wasn't Taylor Swift because she was probably 7 when this came out. But you know, what would you do? And that's the problem they posed to the documentary filmmakers. And then based on those discussions, then the researchers, Pat, Peter, and I, or whomever, synthesize the consensus that we find and express it in the form of a code. And then that code is vetted by lawyers, right? And so obviously, ultimately, fair use is still a legal doctrine. It needs to pass a legal test that judges will administer. And so we take what the communities came up with based on their intuitions of legitimacy and their needs and their mission, and we run it by a team of copyright law experts. And they're from a diversity of fields. So we've got academic experts, but we've also got publishers' lawyers, we've got artist lawyers, and based on their input, we go forward with the consensus. And consistently, the communities get it right, by the way. We've never had the lawyers say, sorry, you got it totally wrong. Sometimes they tweak the wording, right? It's like, I think you maybe put an apostrophe there. But they've never said, no, they got it wrong. This is not fair use. Each of the codes is expressed as a series of principles and limitations. And these principles and limitations are intrinsically linked, right? So the principle will identify a broad category of practice that is fair. You know, it is fair use to incorporate incidentally captured posters in a documentary film, and so on. And it will describe the situation in some detail. And then there will be limitations that will say, but be careful, right? This is something that would give us pause. So it's okay to incidentally capture posters and so on, but if you start putting posters on the wall and set designing the situation, that gives us pause as documentary filmmakers, right? At that point, you're making artistic choices. You're not documenting reality. And so that's something that's in the code. And so the limitations given outer bounds. In the context of libraries, we had librarians who gave us enhancements that were like super good. Not everyone had enhancements, but librarians are very conscientious people. And so So in the context of the librarian's code, you'll find not only limitations, but you'll find things that you can do that are above and beyond the call of duty, if you are so inclined. The purpose of these best practices is to enable rather than to preempt reasoning, right? So all of those old guidelines, the whole point of the old guidelines was so that you don't have to think, right? You don't have to think about what you're doing. You can just count words and call it a day, right? And none of the codes works that way. These principles are stated very broadly on purpose. They include words like legitimate and reasonable that are words that require you to make judgment calls, right? And so it's still not going to be the end of thinking for folks on the ground, but what they do is articulate values and outer limitations to those values that then you can apply to your situation. Limitations in this context, by the way, are not bans. So these are professional values. Professional values evolve. And so none of these codes portrays the limitations as legal doctrine now and forever. This is the sense of the community as of 2005, right? And so it's not meant to squash experimentation at the margins. And if you're feeling like something you want to do is very important and you can describe why it's important and legitimate, go forth and conquer. The goal of the best practices is not to stop you, but to open you up to the possibilities. Try this at home is the ultimate message. You know, a lot of these talks about copyright, and boy, if you ever see a talk and it's billed as copyright compliance, go away. Don't go. Just don't go. Copyright is not like pollution, right? You can't comply. That's not the way the law works. And so a lot of the rules that you hear and a lot of the guidance you get about copyright will say, you know, don't even, you know, here are some numbers, stay within those numbers, and, you know, if you have a question, ask a lawyer, right? And that's really not the way these best practices are intended to work. They are intended to empower professional communities to make these decisions for themselves. You can think through these issues. You should, in fact, think through these issues. So let me tell a success story. The very first code that was developed was the Documentary Filmmakers Code. It was developed in 2005. And there were instant results. TV programmers who had shied away from documentaries about certain subjects like Disney were suddenly willing and able to air those documentaries once there was a strong statement from the documentary community that these are our values and this is what we do. New kinds of films got green-lighted that couldn't get made before. You know, there was a whole movie about the MPAA's rating system called This Film Is Not Yet Rated. And almost all of it is just other people's movies with Kirby Dick speaking over top, right? And that film couldn't have gotten made without this kind of statement. The most important thing, and something that's a little obscure, so I'll explain it a little bit, is that insurers of errors and omissions began to insure these films that relied on fair use. Insurers of errors and omissions are a kind of necessary adjunct to filmmaking, because filmmaking is a huge enterprise. Every film and even every TV program purchases an insurance policy that just says, in case we forgot something, in case somebody didn't sign a release, or in case there's a clip that we didn't get permission for that we needed it, insure us, pay the guy if he shows up, right? Or defend us in a lawsuit if we get sued by somebody that's unhappy. And so movies routinely have to think about copyright and legal liability, right, as a matter of course in order to get made. And so these insurers are the de facto judges. Sort of, these cases don't go to court, they go to insurers. And if the insurer says, I won't insure the movie, then your movie doesn't get made or it doesn't get seen. And so they are the real judge, jury, and executioners for movies. And what happened shortly after this code came out is that one of the insurers said, okay, if your film complies with the best practices statement, we will insure you for X dollars. And then another insurance agency saw that lots of people were now, documentary filmmakers, were suddenly going to that guy. And he said, all right, well, we'll do it for X minus 1. And they bid each other down to 0. 0. And so now you can make a fair use claim. It used to be that insurers would just say, show me your permissions book. I don't want to hear the word fair use. Now you can make a fair use claim at no incremental cost. Now, it is an insurance company's job to monetize risk. And so if they are charging you zero, how risky do you think they think it is, right? And so far, no one has been sued and lost. One person was sued as the code was being made, and he won. And no one has been sued since, and certainly no one's been sued and lost, who's complied with this code. And now it's a cottage industry. There are lawyers on the West Coast who sort of 75, 80% of their business is representing documentary filmmakers and helping them walk through this code and make sure that their film complies. Hate that word. Is consistent. So I wanted to share with you guys some of the go-to codes and principles that I think you might find useful as you try to assemble these ePortfolios and similar multimedia projects. So the first one and the most obvious one is this Code of Best Practices in Fair Use for Media Literacy Education. This is one of the earliest codes that they developed. And some of it is kind of K-12-ish, right? But some of it is much more universal. And Principle 4, I think, is a kind of declaration of independence for students. And it says, educators using concepts and techniques of media literacy should be free to enable learners, that's students, that's you guys, most of you, many of you, to incorporate, modify, and represent existing media objects in their own work, right? It is very strongly felt in this community of media literacy educators that if you can't reuse media in the context of commenting on, thinking about media, then you just can't do it at all. This is absolutely foundational. Another important code for you guys is the Code of Best Practices in Fair Use for Open Courseware. Because again, open courseware is a movement among colleges to make educational materials freely available on the internet, right? And a lot of these educational materials are sort of, well, they're educational. They involve commentary, criticism, taking content, putting it in context, talking about why it matters. And so you'll find in there, for example, Principle 2 about critique and analysis, right? The investigation of pre-existing works of authorship is an essential part of education, right? Freedom of inquiry and freedom of expression. So this is a core example of fair use. So if you're criticizing something and you need to include a screenshot, an excerpt, a quotation, or in some cases the entire thing to make your point, that is a fair use under the best practices. Similarly, illustrative uses. So maybe you're not criticizing the thing, right? But you need to portray and explain information in the context of your presentation, right? So in nonprofit education settings, the instructor's right, and I think here there's a nice analogy to anybody that's doing something with multimedia online. If you're teaching a lesson, right, you're trying to make a point, then the instructor's right to use relevant examples, right, maybe houses and imitation houses, has never been successfully challenged in a court of law. Right? This is foundational stuff. Educators need to show examples to educate. Principle 6 of the Code of Best Practices in Fair Use for Online Video. This is a really fun one because then here we're really talking about the sort of Buffy versus Edward type folks who are on the cutting edge of online fair use. Quoting in order to recombine elements to make a new work that depends for its meaning on often unlikely relationships between the elements, right? This is a mashup, right? And if you're mashing up content where you're creating new meaning by juxtaposition, putting things side by side to make a third point that isn't made by either of the original things, well then, by golly, you're doing fair use. And then finally, there's a great best practices that just came out from the journalism community. The Society of Professional Journalists and others put together this statement, and one of the statements that I think is interesting and applicable for you guys is the use of copyrighted materials as proof or substantiation in news reporting or analysis, right? And so if you've got to make a point, and no one's going to believe you unless you've got the photo, right? That's sort of one of those rules of Reddit, show me the photo. If you don't have a photo, you can buzz off, and so you will need to document sometimes the facts that you need to prove. And when you do, when you need to show evidence of your claim, or to support or negate the assertions of someone else that you're studying, well, by golly, you're doing fair use. So let's go back to those common scenarios that I talked about a little while ago and see what we can do with them, right? Well, there's Ms. Swift, right? Remember, should we blur out Ms. Swift? Well, probably not, right? Probably not. And the documentary filmmakers say fair use should protect documentary filmmakers from being forced to falsify reality, right? There's a Taylor Swift poster in the girl's room, or the guy's room, it can happen. What? They're in my room. Just kidding. So you can't. It would be untrue to blur it, right? It is a fact. It's a fact that you captured in your camera. It is something that you've documented. And where a sound or image has been captured incidentally and without pre-vision, i.e. you didn't stage manage it, you didn't say, well, it'll look more high schooly if I put a Taylor Swift poster in the back, as part of an unstaged scene, well, then it should be permissible to use it. To a reasonable extent as part of the final version of the film, right? And by the way, just, a little point of historical interest, the reason that logos are blurred in TV shows is because the producers want to get paid to show the logo. So it's the opposite. It's not I owe Adidas money, it's Adidas owes me money or I'm not going to show their logo. So it's like, if you want a product placement, buddy, then, call my lawyer. So it's quite the opposite. So far from being obliged to blur the Adidas logo, you can maybe extract some money from Adidas if that's what you're interested in. And so back to Buffy and Edward, which is a real video, which I strongly recommend you find and watch. It's fantastic. And this version actually is the pop-up video version that he made, which actually involves pop-up commentary that really adds context and criticism and says, here's what I'm doing here. Buffy, Twilight advocates abstinence, and so Edward has been remixed into a much-needed sex ed class, right? No surprise, quoting in order to recombine elements to make a new work, fair use, right? This is quite strong example of fair use. What about dropping in that Kanye West song on your video? Well, that's kind of our ringer. In the case of music, the content should not function as a substitute for a sync track. And that's kind of a term of art, but for filmmakers, basically, if you're going to take music and use it as background music to evoke a mood, that's something filmmakers pay for. That's their practice. That's a way that musicians and record labels make money. And if you're just sort of using it to set a tone or set a mood, it's hard to say that you're transforming it. It's more like it's transforming you, right? And so there's a hard argument to make there. I'm a user's lawyer by nature, and I would make it if I had to. But the community of practice has pretty well decided. Sync tracks, you need to pay for those. That's the way we do it. What about our friend, the Frank Lloyd Wright critic? Can he take things from Google Images? Well, probably so, right? Proof or substantiation. If I just say to you, there are thousands of imitation Frank Lloyd Wright houses, or there are hundreds, or there are tens, who knows? Maybe there's none. I made this up. I have no idea. You need some evidence, right? Don't you kind of want to see some images? Don't you kind of want some illustration, some facts to back that up? I think, depending on the context, this is the kind of thing that people who tell stories with facts in them often do, people like journalists. What about my senior thesis about Portuguese water dogs? Trick question, right? US government works are not copyrighted. And so, a little word to the wise, if you can possibly find a photo taken by the White House photographer that will help you, go for it. Because everything he does is free to all of us, because we pay his salary. So anything made by the government is ours and belongs to the people. But might there be a fair use argument here? Well, I want to give kind of a lawyer's answer, which is it depends, right? What purpose is the photo serving? Where is it posted? What are the words that are around it, right? What are you talking about? Why do you need this photo? Is there a transformative argument? Is it evidence or claim for some kind of argument you're making? Or is it sort of mere decoration, right? I like water dogs. Oh, this is a pretty one. That's going to be hard to defend. Well, what about the guy talking about presidential pets? Well, then I think we're closer, right? Then I think we're closer, and it's much easier to imagine that there's going to be an argument there, a reason for having that in there that is adding value and not merely enjoying the lovely dog. And then I wanted to throw this one in. I'm giving a talk about the use of multimedia in students' online portfolios. Can I use a picture? Yes, of course I can. I can do whatever I want. Sue me. It took me a very long time to assemble the 130 articles that I cite in my thesis. Can I post them to the open web as a zip archive so that others who are interested don't have to do this all over again? And there's actually, this is another one that's ruled out by a limitation. So in fair use for scholarly research in communication, the scholars in that field said, well, if you want to archive, that's fine for your personal use, right? That's a standard practice. You find a bunch of articles, you put them in a folder, you keep them for as long as you're interested and as long as you might need to go back to that material. But if you want to open your collection, you should adopt policies appropriate to the medium that will limit access to scholars doing research in the relevant area, right? Posting to the open web sounds like not much limitation to access. And establishing appropriate limitations on the purposes, right? So you want some idea that maybe the other people grabbing these articles are really going to be doing what you were doing or what you expect them to be doing. So again, no clear answers on these. It's always on a continuum, but it's not looking good for our zip archiver. So I want to talk about one more thing. I think I've got time, which is thinking clearly about risk. So even though I think it's not so hard when you've got the best practices in your pocket and when you understand transformativeness to make these kinds of determinations, there is always a non-zero risk that you will make someone angry. And that person could hire a lawyer, and that person could send you a nasty letter. There are actually two kinds of risk involved in any decision along these lines, and I want to make sure that you understand them both. So on the one hand, yes, there's a legal risk associated with taking a particular strategy and pursuing your mission, right? So there's the risk that if you build a building that has more than one story, you will have to build stairs. Someone will slip and fall, and that person will sue you. I guarantee it. I guarantee it. It will happen. And universities take that risk every time they build a new building, and they're happy to do it because one-story buildings are just not that fun, right? You need 2 stories or more most of the time, right? So it's worth it. Somebody's going to sue you, but it's worth it. Sooner or later, somebody's going to be unhappy with you, but it's worth it. And so there's the legal risk associated with pursuing mission, but there's the mission risk associated with failing to act, right? What would it look like to have a campus that tolerated 0 risk of slip and fall injuries? It would be a nightmare, right? At lunch, I was talking with someone who had traveled abroad recently and said there were armed guards at the door of the grocery store in the country where she was visiting, and that those guards were, I guess, ostensibly there to police the grocery store and make sure nobody walked out with any food, right, that they didn't pay for. That's kind of crazy. But it reduces the risk that somebody's going to shoplift, but do you want to live in that world? Is it worth it? Is that the kind of grocery store you want to have? I mean, if I'm running a grocery store, do I care that much about shoplifting that I'm willing to really scare my customers every day? And maybe they get used to it if that's the way everyone does it. But you've got to weigh those risks, right? The risk associated with going forward and the risks associated with not going forward. And so I think a lot of the time folks don't even consider, they think, well, now I'm doing legal reasoning. And the only thing that matters is, am I absolutely 100% sure that what I'm doing will never ever get me in legal trouble? And that's the only kind of reasoning I can do because I'm thinking about a legal question. But in reality, every question is a mixed question. And all these priorities come together, right? And nobody makes any other kind of decision that way, right? Every time you get in your car, there are legal questions, and you don't say, well, my only goal right now is to never ever do anything that might have a legal question, so this is how I will conduct my life. You live your life according to a mixture of values, and I think there are some really deforming things that people do because they assume that copyright risk is some special risk that has to always be 0, unlike every other legal risk in your life. Another important thing to understand is the difference between risk management and knowing your rights. So it's oftentimes folks, when they talk about legal risk, they're really not talking at all about what's legal or illegal. They're not talking about what's infringement or not infringement. They're talking about whether they might get sued. And honestly, it's a different question. And now, in some situations, it's an extremely important question, right? And there are times when you might say, even though I know I'm right, I don't want to be sued, and so I'm going to back off. But it's important to at least make that decision consciously and to know right? And I think to get the sequence right, to know your rights first and to surrender them self-consciously, right? To know that, you know, I really could post this and I would win if I got sued, but I'm not willing to take that risk and I'm not going to do it. And then the last thing is it's really important to estimate that second kind of risk, that will I get sued risk, accurately. Because it turns out the risk that you'll get sued is pretty near zero, period. It's very expensive to sue you. It is very uncertain to sue you, right? So for the very same reason that you think fair use is hard to apply, the guy on the other side has to worry that you might win, right? And what's really scary for the guy on the other side is if you win, everyone else can now do what you did forever and know that they're always okay. And so people have refrained from suing fair users even though they didn't like what they were doing, because they didn't want to have that precedent on the books. And so people like me have to go out and tell folks to exercise their rights, rather than just have it be clear and obvious in some case somewhere, right? So you should estimate your risk accurately. And part of what goes into estimating risk accurately is knowing that not only is the other guy just as uncertain about fair use as you are, in fact, much more so, because you now know a lot more than they do, right? Most of the plaintiffs that would possibly be upset about copyright, they don't really understand what their rights are either. They have no idea whether they would win or lose. They just kind of get upset and call somebody and say, no, I don't like it, send them a nasty letter. So you know a lot more now than they do about what your rights are and how likely you are to win. There's other things that you need to know and that your lawyer probably knows, and that their lawyer knows, that makes it less likely that you'll get sued. One is the doctrine of state sovereign immunity. This is a public institution. It is an arm of the state. The 11th Amendment of the Constitution says you can't sue an arm of the state for money damages unless they say that you can. And no states that I know of have said that you can in this context. And certainly the sovereign state of Alabama has not. And so no one can sue you for money damages at this university. So there you go. Right there, there's no money on the line. They can sue you and make you stop doing what you're doing. And that might really stink, but they can't get your money. There's another doctrine called qualified immunity, which says that anyone who is an officer of the state who has a reasonable belief, or rather who violates a federal right, which you would be doing if a judge said, okay, fine, you infringed. Even if it turns out that a judge says you infringed, if that infringement of a federal right was not a clearly established federal right at the time that you did it, again, you're off the hook for money. So even if there were no state sovereign immunity, even if somehow they got around that, there's qualified immunity, which says that if the federal right is not clearly established, and this has been invoked in the very opposite case, which is the UCLA case about video streaming. And the UCLA case, the judge said, well, I'm not going to say right now whether video streaming is fair use or not, because I don't have to, and judges love to not answer questions if they don't have to. But I am going to say that everyone involved here gets qualified immunity because, and he did a quick sketch of what a fair use argument might look like in less than a paragraph. He just said, well, you know, you might say the purpose is transformative, and you might say the kind of works are not that important. And in less than 4 sentences, bam, that's enough fair use rationale to get qualified immunity. And then finally, there's a separate provision in the Section 504(c)(2) of the Copyright Act that says any employee of a nonprofit public educational institution, doesn't have to be public, any nonprofit educational institution who has a good faith belief that their use is fair cannot be subject to statutory damages. So let's say they get around everything else and they finally prove, yes, infringement, and yes, we're going to get some money out of this guy. All they're going to get is actual damages, which, given the standard kind of projects that you guys do, how much do you think you're harming anybody, right? What are those actual damages going to be? Statutory damages are those scary numbers that you hear about, right? Jamie Tenenbaum and those guys who are, anyway, the defendants in the file sharing cases who have to pay $6 million for putting 12 MP3s on the internet. That's statutory damages. Actual damages would be like $7, right? What they would have paid for the CD. Provable actual damages. So, you have a lot of protection. There's a lot of reason why no one would really want to bother suing you. Another thing I might add is that the people who might sue you, the publishers and the authors, they're already suing other people. They're busy. They're suing Google, and they're suing Mahati Trust, and they're losing and losing and losing. And they're on the hook for many millions of dollars. And so they're probably not going to be inclined to sue anybody else for a while. So, I want to leave you with this, which shockingly, I haven't said yet. It's kind of a cliche of fair use. If you ever go to anything about fair use, somebody will inevitably say this, which is that practice makes practice. Fair use is like a muscle. And the more you exercise it, the stronger it gets, right? When your community understands its rights and begins to think clearly about everything that it could feasibly do as a transformative exercise toward its mission, you will get better and better at it, and you will do more and more with it. But the inverse is also true. And you can give up your rights by not exercising them, by paying people when you don't have to. You can establish a custom of paying when you don't have to. And once that custom is established, courts won't interrupt it, and you will be stuck. And so as you embark on this new project of ePortfolios and online multimedia, you really need to think carefully about what kind of things you want to be doing and paying for the rest of time, right? What should these things, how should these things be done in a way that is fair and legitimate, and that puts you, that puts the institution in the right place relative to everyone else in the sort of copyright ecosystem, right? Do you want to be doing things that advance your mission and that incorporate that advance learning, or do you want to be paying and paying and paying and paying and paying and paying? So there's a lot more information. There's a kind of syllabus up here at the front with a long list of links and documents that you can consult. The centerforsocialmedia.org, which they literally changed their URL today, but this redirects to that, whatever it is. They changed their name and everything. It's driving me crazy. But the Center for Social Media has all of these codes, and they're all like 12, 13, 14 of them, and they're all there. They're free. They're PDF and HTML. You can link to them. ARL.org/fairuse, where I used to work, has the librarian's code and a whole lot more in terms of educational materials about fair use, more context, FAQs, even slides you can use in your own presentations. IPClinic.org is where I work now. That's the clinic at Washington College of Law. We take cases, so if you do get sued, give us a call. And PIGIP.org is the kind of IP think tank at AU. And there's a lot of really great information about fair use and copyright at their website. So all that stuff is again collected here at Center for Social Media. This is the book that Pat and Peter wrote. If you really want to dig deep, called Reclaiming Fair Use. It has a much deeper version of that history that I told, as well as how to write your own code for whatever community you're in. You don't need our help. It's a fairly simple process if you want to do it. Feel free to share this presentation in its entirety. I don't care. You can do it. You have my blessing. And for excerpting, you can kindly employ the principles of fair use.